Okay, so now having established the basics of what is administrative law, judicial review, how the standards of review work for different types of exercises of public power, and what the separation of powers means in the COVID context, and also having discussed what the regulatory environment is and where the regulations come from in Section 26 and 27 of the Disaster Management Act. Now we're going to discuss 4 different cases that have been brought to different courts around the country, all of which have some administrative law related arguments in them. We are discussing these cases, which are continued litigation, which is live right now. We're not 100% clear on when the cases will be argued, though presumably all of them will be heard in the coming weeks or days. And we are discussing them just based on the notice of motion and founding affidavits by which these cases have been launched. So we're not going to get into what the government is arguing in reply or any of the detail and heads of argument. This is just to explain the general administrative law issues being raised and some of the issues that will be around it. So how we're going to approach this is that I think that Melanie, you're going to discuss 2 of the cases brought by the Democratic Alliance first, and then I'll discuss the other 2 cases. But we'll try and discuss some of the issues emerging out of it once you've provided the summary of each case.
All right, so I'm going to share the screen so that we can just have a rough idea of each case as we deal with it. So the first case that we are going to talk about is the Democratic Alliance versus the Minister of Cooperative Governance and Traditional Affairs case that has been brought in the Constitutional Court. And so in this matter, the Democratic Alliance is seeking direct access to the Constitutional Court, which is an extraordinary thing in itself as a matter of constitutional procedural law. But what the DA is asking for, in essence, is to have Section 27 of the Disaster Management Act declared unconstitutional and invalid. So this isn't so much of a typical admin law case, because it's a case to declare a provision invalid. So it's really a typical constitutional law case. But it raises some interesting administrative law issues and separation of powers issues. So the founding papers are over here, and they are brought, or at least they are deposed to by a member of parliament and representative of the Democratic Alliance, John Steenhuisen, who you might have read quite a bit about in the press lately. And the main thing that he's asking in these papers is whether there is sufficient parliamentary oversight and involvement in the raft of delegated legislation made by the executive branch to regulate lockdown. So what's happened is, in terms of the Disaster Management Act, the legislature has given the power to the executive branch to regulate a state of affairs that is a disaster. And we know that a ton of regulations have been issued, or at least promulgated, I suppose is the right word. I'm not 100% sure now, but there are a ton of regulations, but also a ton of directives. So the regulations are introduced by the Minister of Cooperative Governance, and then she's also empowered to authorize other ministers to make directions, which they have done. And the crux of the DA's argument is that the Disaster Management Act, in empowering the minister to make these regulations and to allow others to make directives, doesn't allow Parliament to exercise sufficient oversight over the executive branch when it fulfills this role. And this is particularly so given that the Disaster Management Act confers very wide-ranging power on the ministers. and we've all experienced this. It confers wide-ranging powers to suppress our freedoms in a number of ways. So our freedom of movement is one of the most notable things that's been suppressed during this state of disaster that's been declared, and under the regulations and the various directions that have been introduced in terms of those regulations. And so what the DA argues is that there's an unconstitutional delegation of power from the legislature to the executive. So the legislature, as a matter of separation of powers, must exercise its legislative function, and the DA is in essence saying they've given too much of that away to the executive branch. And one of the arguments that's quite interesting is that the effect of this is to permit a de facto state of emergency without the normal oversight role that Parliament would ordinarily have in a state of emergency under Section 37 of the Constitution. Because the Disaster Management Act doesn't explicitly allow for Parliament to have that oversight role, and so it allows the executive a lot more power than it probably should have, or arguably should have, on the DA's view. And so the aim of their application is to ensure that Parliament has opportunity to exercise oversight over the power of the executive branch. And so you'll see in the notice of motion that what they ask is for a declaration that the National Assembly may disapprove or declare any declaration or regulation or directive issued under the Disaster Management Act invalid. So that's the kind of oversight we're talking about that the DA would like Parliament to have over the executive's conduct. So that's the first application that's been launched to the Constitutional Court. And then, yes.
Because this raises very different questions to the other one. So
Okay.
I ask you some questions.
Sure.
So the administrative law question that is here is about delegation of power. And so the question is, can you just say what guides the court in determining whether or not the delegation of power that is made in a certain act will be lawful in terms of the lawfulness requirement that we discussed? What are the general principles?
Of what guides a lawful delegation of power? Well,
yes, because the DA here, I understand, is arguing, using constitutional court cases, that the delegation is too broad.
Yes.
It provides unlimited power and discretion to the minister.
Yeah. So a delegation of power will be lawful where it is authorized, right? That's the basic requirement of any lawful conduct, at least. So what we have to look to ask whether Parliament has allocated or delegated an appropriate amount of power to the executive branch to then perform various administrative or executive acts is the Constitution, because the Constitution determines the extent of power that may be lawfully delegated to the executive. And one of the things that informs the transfer of power from one branch to another, from Parliament to the executive, is how much, what is the impact of that power? So when we look at, I wanted to find the relevant paragraph. So that looks at the Act. Okay, so here's the section dealing with the arguments on delegation. So what the DA is arguing is that the nature of the power that's being delegated is extensive. So there are sweeping, wide-ranging powers where the ministers are acting without any policy framework guiding their conduct that could help constrain their powers. And that these regulations, as you can see here, don't merely deal with minor regulatory details to fill in a scheme created by Parliament's legislation, but rather they are extremely wide-ranging. So one of the things courts will look at to assess whether a delegation is lawful is the nature of the delegation, the nature of the power that's being transferred. And here those powers are very wide-ranging. And then another is the extent of the delegation. So how much, if Parliament has all this power, how much of that has been given? And here, what's being argued is because the Disaster Management Act doesn't allow for parliamentary oversight, the extent of the delegation is essentially complete. The executive can do as it chooses in regulating this disaster. And so that's another indicator that the delegation might be too much and might be unlawful, go beyond what Parliament is permitted to delegate in terms of the Constitution.
So the DA here is essentially arguing that the executive has been allowed by Parliament to rule by decree without parliamentary oversight. And so that is a violation of the separation of powers, but it's also unlawful in terms of the fact that it's an unlawful delegation. The last thing is that then the remedy that they ask for is not, although it's been sometimes understood publicly to be that, to declare the whole act unconstitutional and remove it from effect. They've asked for a reading in because it seems that the DA believes that if those two items that you've listed in the notice of motion are put into effect or read into the legislation to allow parliamentary oversight of the enactment and enforcement of the regulations, that this would save the act and make it constitutional.
Yeah.
So there's the next case will be about the substance of some of these regulations, but this is a case that's about what we need to do to make sure that the Disaster Management Act itself is consistent with the Constitution.
Yeah, I think that's right. And it goes to the relationship between the legislative branch and the executive branch, because of course, how this relates more to administrative law is that the executive branch is only allowed to do that which statute empowers it to do, or which the Constitution empowers it to do. So how does the executive get powers? Or how is it empowered to do anything? Well, it's empowered by either statutes created by Parliament or by municipal councils or by the provincial legislature, or it's empowered by the Constitution. And anything that the executive isn't empowered to do, it cannot lawfully do. So it can only do what it's lawfully empowered to do. And so if the Disaster Management Act is giving the executive power it shouldn't lawfully be able to perform, well then that would be a proper reason to curtail the power provided for in the Disaster Management Act. And I think this is a particularly interesting angle of attack of what's going on, because it is quite respectful to the executive. It's not saying disagree with everything you're doing and the minutiae. It's not attacking the minutiae of the lockdown regime. It's simply saying that the executive branch must work together with Parliament and to ensure a more kind of democratic society in the way these lockdown regulations are being rolled out. So it's not just a minister going into a back room coming out with an amusing announcement. It's rather a scenario where there's been more deliberation, more transparency, and more of a multi-party process involved to come up with appropriate regulations. And those things can be done on an expedited basis. It's not like Parliament's involvement will delay things so much that we can't have proper regulations. We know that the president's announcement was over a week ago now, right? I've lost all sense of time, but there's no reason why parliamentary bodies couldn't have chimed in at this stage on what the regulations should be for level 3 lockdown and how to achieve more equitable regulations that the broader South African community could buy into because they have more faith in the process. I think currently there's a strong public sentiment that of mistrust towards what's in the regulations, and that could partly be addressed by involving Parliament and having more transparency and more participation.
Okay, so then we're going to move to several other cases. So two of them, the DA case you're going to go over now and the ESOL case, attack specific aspects of these regulations. So the rules that people are not enjoying. And then the last one, we come back to the Helen Suzman Foundation case, goes back to being about the structures of power and parliament and democratic process. So maybe let's look at the first DA one in which they're a little bit more aggressive towards what the government's response has been.
Great. I unfortunately can't find that with the many hundreds of tabs that are open on my, let's see if it's this one, on my desktop at all times. So yeah, here it is. Okay, brilliant. So the second DA case is an urgent application that's been brought in. We can see the Gauteng Division, Pretoria, so the North Gauteng High Court. So it's also the Democratic Alliance challenging conduct of the Minister of Cooperative Governance and Traditional Affairs. But you'll see they've also cited the Minister of Transport and the Minister of Trade and Industry being two bodies that have been empowered to issue directions by the Minister of Cooperative Governance. So we'll come back to that in a moment. And in theory, this case would have been heard yesterday, but I don't believe it was. And that might could be for various procedural reasons or strategic reasons. But what's important here is what the DA is challenging in this case is the constitutionality of specific regulations and specific directions that have been issued in terms of Section 27 of the Disaster Management Act. So whereas the previous case was challenging the constitutionality of the Disaster Management Act itself, this case is challenging the manner in which the Disaster Management Act is being implemented by the Minister of Cooperative Governance and by various other ministers. So this is much more of an administrative law case in the traditional sense, in that we're concerned with public power that is engaged in the day-to-day running of the state. And so we immediately have to ask ourselves, well, what is the proper pathway to review in this case? And should we review the conduct on the basis of PUDGA because it's administrative action, or should we review this as public power that is not administrative action? And as you've pointed out, the key difference is that more or higher standards of scrutiny apply if the conduct is administrative action, and the court can apply a higher standard to the action than if the conduct is executive action, in which case the court can only ask in the review proceeding whether or not the conduct is lawful and rational, which is a lesser standard of scrutiny. So the DA is in essence in this matter asking that various conduct be declared unlawful, various regulations and various directions. And it's useful to just go to, so here you can see that the applicant is, or the deponent is at least Glynis Breitenbach, so another infamous or famous, depending on your perspective.
I'm not sure, I don't know, I can't see that on my screen. I'm not sure if everyone else.
Can you not? Oh dear, okay, let me.
I see the Disaster Management Act, Chapter 1 at the moment.
Oh, and now?
Now I see.
Okay, sorry, let me fix that. So it wasn't matching up for some reason here. Okay. How about now?
Yeah, I can see it.
Okay, brilliant. So we just go back here for a sec. So we can see we're in the High Court, North Gauteng, and we have the Democratic Alliance instituting review proceedings against these various ministers, doing so on an urgent basis, and seeking to set aside certain regulations and certain directions that have been issued under Section 27 of the Disaster Management Act. So here we have Glenys Breitenbach as the infamous or famous DA representative, as the deponent of the affidavit. And then there are several decisions that she is speaking about that the DA wishes to challenge and have the court review. The first decision relates to the imposition of a curfew, which is obviously a very extreme measure implemented to supposedly give effect to the Disaster Management Act. The second is transport restrictions that are linked to the curfew. So no one can use public transport after a certain time, so everyone must be home by 8 p.m. The restriction on exercise, but that we can only exercise between 6 and 9 in the morning, and then certain restrictions on e-commerce. And those restrictions have all been brought into effect either in terms of the disaster management regulations or in terms of directions issued in terms of those regulations. And one of the things that the DA is arguing is that the conduct under scrutiny is administrative action. So there's a section where the deponent makes submissions on this point and asks, what is the standard of review? So we refer to this as the basis of review or the pathway to judicial review. And the deponent starts off by saying, well, legality, of course, regulates all public acts. And here we're challenging the lawfulness and the rationality of certain public acts. And then she goes on to say that the relevant public acts here are administrative acts regulated by PAJA. And so the various grounds of review under PAJA are applicable. So here she speaks about, although that this is academic, which is a position I fundamentally disagree with, she says that PAJA is applicable. She says that the court is obliged by PAJA to engage robustly with the impugned restrictions. So she's actually seeking to impose PAJA's higher standards of scrutiny, although she says to some degree this doesn't matter because the conduct would be reviewable on the basis of rationality and lawfulness anyway. And so there's a number of things she says about the different decisions that she's challenging, and the gist of it is that they are disproportionate measures, that they are irrational measures for various reasons, that they violate a number of fundamental rights. And so for all of these reasons, she seeks to have the various regulations and directions set aside.
So the general basis of the claims for rationality or irrationality here are, as we discussed, that the Democratic Alliance says that they have nothing or very little to do with combating COVID, and in any event they can't combat COVID. One of the interesting questions that comes out of this is that these were a challenge to the level 4 regulations. So the way that the government is dealing with this now, the regulations now allow for 5 different levels. Level 5 being total lockdown that we were on, level 4 being what we enjoyed, if I can say that, during May. And level 3 will be what the president has announced we're going to in June. So from the 1st of June. So the question then would be, does it affect the DA's challenge that level 3, for example, will allow for us to exercise anytime? does the DA still have a relevant challenge to the level 4 regulations, even if we're going to level 3?
I mean, I think this may be partly why the DA has delayed the hearing, is that it may be trying to revise some of the relief it seeks. But I also think the answer is no, because these restrictions could come back should we revert back to level 4. So I don't think that the challenge becomes moot if we move to level 3. But just to go back to the rationality point, so the main ground of review is that the conduct of the minister is irrational and that it's unlawful, the main 2 grounds. So in other words, the conduct doesn't meet the standard of rationality and the standard of lawfulness. And a lot of the argument is that the standards don't, at least the directions and the regulations don't pursue the purpose of the empowering provision. So they don't pursue the purpose of ensuring public health and safety, because it makes no difference that you don't become more at risk if you're going for a run at 9 or 9:01, I think is one of the examples they use. So that kind of distinction that they are making shows the irrationality of the approach that's been adopted, that at 9:01 you become a criminal if you're running, but at 9 you don't, and 9:01 makes no difference to your safety and your risk of catching COVID or spreading COVID. So that's an example of how the decision making isn't rationally related to the purpose of the empowering provision. And I would say also why it's not rationally related to the information before the decision makers, or the reasons for which the decision is taken, or the purpose for which the decision is taken. So for all of those reasons, you could find that particular regulation to be irrational, just as one example.
Then the last question on this is that on the paragraph that you're on here, there is, and it's just a notice of motion, so it's not what their lawyers are arguing in court. But in these cases, there seems to be some mix-up between the human rights standards of review and the administrative law standards of review. So here, for example, in this paragraph, they're saying that it's inconsistent with PAJA, but then they're talking about a limitation of rights which is disproportionate and unjustifiable. What's the relationship between the human rights that might be violated by the regulations or limited and the administrative law grounds of review?
Well, I mean, there's a number of relationships, but what I would say is that administrative action can be unlawful if it's otherwise unlawful or unconstitutional. So one of the grounds of review for unlawful administrative action is section 6.2 Roman numeral I, which is action will be reviewable if it is otherwise unlawful or unconstitutional. So I would say that if the conduct violates a number of rights, it could fall within that ground of review. I'm not sure if that was the response you were looking for, but that's at least one of the relationships between a challenge to administrative action and other conduct that also violates other rights.
It's just that, so I was looking to flesh it out because there are different challenges. There are possible different challenges. You could say that the restriction on our exercise rights is unconstitutional in terms of the freedom of movement, and you wouldn't need administrative law to get there. So then within the administrative law review on rationality and lawfulness, you could also make the same argument.
Yeah.
But there are separate ways of challenging the same provision. So it's just interesting to see what types of arguments are being made and where. But this will come up again and again in the other 2 cases too. So we'll have a chance.
I think it's also important to bear in mind that all the rights in the Constitution are interrelated and are meant to be mutually reinforcing of one another. So it's not problematic to rely on Section 33 of the Constitution, the right to just administrative action, as a basis to challenge a violation of another right, the right to freedom of movement, for example. And this kind of thing happens all the time. It's one of the phenomena that Dani Brandt refers to as the proceduralization of rights litigation, where administrative law arguments are used to address all the violations that occur, instead of trying to explain why the regulations are a violation of a particular right and what the content of that right is, and how the right is being limited, and using a Section 36 analysis. It's very common for lawyers to use administrative law to do all of that work, and to say the conduct is unlawful as a matter of administrative law.
Okay, so that's, I think, what the DA is up to. So both the challenge to some specific regulations and directions, some of which will still apply, others of which have been overtaken, but that may or may not matter. And then the other challenge, which is to the Disaster Management Act. So they have raised these several problems. And then we have two other cases